Last order, we'll start off with the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
So for the respondents in the audience, I don't think I recognize them. So my name is Drew Smith. I'm the Code Enforcement Special Magistrate for the City of St. Cloud. I'm not employed by the city. I am hired as an independent fact finder. So my role in these proceedings is to hear the evidence and make an independent decision on the evidence and testimony that's provided to me. The order of each case will be Code Enforcement Officer will present the city's case. When they are done, if anybody would like to ask a question of the Code Enforcement Officer or any other witnesses the city presents, you have that opportunity. Otherwise, if there are no questions, I will hand it over then to the respondents, and you will have your opportunity to present to me anything you'd like me to hear. When I've heard all the evidence and received any testimony you have, or when I've heard all the testimony and received all the evidence you have to submit, I will enter today a verbal ruling that will be followed in the mail by a written order. That usually goes out either the end of this week or early next week, so probably next week you'll have a written version of the order that I enter today. And with that, clerk, you may call our first case.
Case number 2023-1946, Sothia Sock owner, Hung Lei owner, location of violation 11 California Avenue, St. Cloud, Florida.
Yes. Anybody else who's going to present testimony today, if you'll stand where you are, I'll swear everybody in. Stand where you are and raise your right hand. Anybody giving testimony? No witnesses? Testimony? Do you all swear from the testimony you give today is the truth, the whole truth, and nothing but the truth? Thank you.
Good afternoon, April Bennett, Community Compliance Officer. I am presenting the case for the property located at 11 California Avenue. At this time, I would like to enter in evidence the following items: copy of the courtesy notice sent by regular mail to the owner of record and the tenant, copy of the notice of violation sent by regular mail to the owner of record and the tenant, copy of the notice of violation sent by certified mail to the owner of record and the tenant, copy of the statement of violation and notice of hearing sent by certified mail to the owner of record posted on the property and City Hall, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code section in violation of, a copy of the deed to the property, and a copy of the costs incurred if the magistrate finds the respondent in violation in the amount of $244.69. And they are not here. On December 12th, while on routine patrol, I observed an accumulation of miscellaneous items in the rear yard in unsightly condition, an above-ground pool without a permit, and a fence in disrepair, and an expired permit for the fence at this location. 3 photos were taken. On December 13th, a courtesy notice was sent by regular mail to the owner of record and the tenant. On January 2nd, a re-inspection was performed, and I verified that the violations were not corrected. 3 photos were taken. On January 3rd, a notice of...
Pause you 1 second. In the photograph, there's a lean to that fence. Is that an actual lean, or is it just the photograph?
It's leaning a little bit, but that was not the intention of the photo. The missing sections were more the intention. Okay. On January 3rd, a notice of violation was sent by regular mail to the owner of record and the tenant. On January 16th, a re-inspection was performed, and I was able to verify that the fence was repaired, curing that violation. However, the accumulation, unsightly condition, expired permit, and no permit for the pool were not addressed. 3 photos were taken. On January 16th, I received a call from the tenant to discuss the violations, and additional time to cure the violations was granted. On February 5th, a reinspection was performed, and I was able to verify that there was progress being made on cleaning up the property. However, it was still in violation. The permit was not obtained for the pool. The fence permit was still in expired status. 2 photos were taken. On February 6th, a notice of violation was sent by certified mail to the owner of record and the tenant. Both notices were signed for. On February 22nd, a reinspection was performed, and I was able to verify that additional cleanup had occurred. However, it was still in violation. The permit was not obtained for the pool, and the fence permit was still in expired status. 3 photos were taken. On February 28th, a reinspection was performed, and I was able to verify that the violations were not corrected. 2 photos were taken. On March 4th, a statement of violation and notice of hearing was sent by certified mail to the owner of record, posted on the property and City Hall, and an affidavit was completed. 1 photo was taken. On March 12th, the certified mail was signed for by the owner of record. On March 14th, I received a call from the tenant advising that the fence permit was closed out and he had applied for the pool permit. I was able to verify that the fence permit was closed on March 12th, and the building department confirmed that an application for the pool was received on March 14th. On March 18th, a reinspection was performed, and the property is not in compliance. I was able to observe accumulation in the rear yard in an unsightly condition. I also verified that the pool permit was denied by multiple departments. 4 photos were taken.
Where's the pool?
It's inside the fence. You can't see it unless you're looking through the slats of the fence. When the fence was damaged, I was able to see it. When he put the repaired slats up, I couldn't see it any longer, but it's still
Above ground?
above ground, yes. On March 19th, I was able to verify that zoning will not be approving the application for the pool due to it not meeting the setback requirements. I also received a call from the tenant advising that he's just going to remove the pool since the application will not be approved. It is the city's recommendation the respondent be found in violation of allowing accumulation of solid waste and debris, an unsightly condition, an expired fence permit, and no permit to be obtained for an already installed above-ground pool at this location and not corrected by the time specified. The city would recommend that the respondent be given until April 1st to correct the violations, or a fine in the amount of $250 a day be assessed until compliance is met. The city would also request the cost incurred in bringing this case before the magistrate in the amount of $244.69 to be paid within 7 days of the written order by the special magistrate, and that concludes my presentation.
So let me walk through the violations. Accumulation of solid waste and debris, that one's still, they have not completely fixed that, right?
Correct.
Have they made any recent progress on it, or they made some early progress and then that just kind of stopped?
They've made a little bit of more progress on it, yes. It's just not enough to bring it completely into compliance.
And the fence permit is good.
That's closed
have
out now,
obtained that.
yes.
Okay. Pool they got. Okay, so then based on the evidence testimony received, I'll find in favor of the city, find that the respondent was in violation related to the expired fence permit, that has been cured, but the cure was made after the time set in the notice of violation, but before today's hearing. Find the respondent is still in violation related to the accumulation of solid waste and debris, and also still in violation as to the installation of a pool without proper permits. We'll order the respondent to cure those remaining violations by April 1st. If not brought into compliance by that date, a fine in the amount of $250 a day will run until compliance is met. We'll also order the respondent to pay the administrative costs incurred by the city in prosecuting the case in the amount of $244.69. That amount will be due within 7 days of the date of my written order.
Thank you.
Case number 2024-18, Sothia Soak owner, Hang Lei owner, John Bergen. Tenant, location of violation 11 California Avenue, St. Cloud, Florida.
Same property.
Same property. Good afternoon, Pam Neal, Community Compliance Officer. I am presenting this case for the property located at 11 California Avenue. At this time, I would like to enter into evidence the following items. Copy of the notice violation sent to the owner and the tenant. Copy of the notice violation sent by certified mail to the owner to both addresses and the tenant and posted on the property and City Hall. Copy of the statement of violation notice of hearing sent by certified mail to the owner and the tenant and posted on the property and City Hall. Copy of the PowerPoint presentation. Copy of the affidavit of postings, an affidavit of mailings, copy of the deed to the property, copy of the code sections in violation, copy of the costs incurred if the special magistrate finds a respondent in violation in the amount of $296.15. And he's not here. On January 3rd, 2024, while on routine patrol, I noticed a white van with an expired tag at this location. The tenant told me the van belonged to his brother and that he would get it taken care of. I took 2 photos. On January 22nd, a reinspection was performed and the van was still there. I took 1 photo. On January 23rd, a notice violation was sent to the owner and the tenant. On February 7th, a reinspection was performed. The van was still there in violation. I took 1 photo. On February 9th, a notice violation was sent by certified mail to the owner to both addresses and the tenant. On February 26th, the reinspection was performed and the van was still there. I took 1 photo. On February 28th, 2024, a statement of violation, notice of hearing was sent by certified mail to the owner and the tenant and posted on the property and City Hall. An affidavit of posting was completed, and I took 1 photo. On March 4th, a reinspection was performed and the van was gone. It is the city's recommendation that the respondent be found in violation of allowing an abandoned vehicle at this location. And the city would like to also recover the costs in bringing this case before the magistrate in the amount of $296.15 to be paid within 7 days of the written order of the magistrate as well. And that concludes my presentation.
I think you answered my question. I had 1 question, but I think you answered it. Oh, it actually was a question for the attorney. Do you want the owners and the tenant to be jointly and severally? How do you want the relief structured in this?
I think he should be.
Okay.
Yes, sir. Thank you.
Really, the liability on this one is for the cost, but if you want the tenant on the hook for that, I'll include them. So I will find in favor of the city, find that the respondent was in violation for allowing an abandoned unregistered vehicle on the property, find that that violation was cured, but it was cured after the date set in the notice of violation for cure, and accordingly the respondent is responsible for the city's administrative costs and prosecution in the amount of $296.15. That amount will be due within 7 days of the date of my written order.
Thank you.
Case number 2023-1954, Preferred Vista LLC owner, location of violation, Neptune Road, St. Cloud, Florida.
Jack Morrison for the city. Good afternoon, Your Honor. Just some general comments, not an opening statement or anything. Compliance Officer Miller will present the case, and Ms. Tisha Manning is here as well to answer any questions and or to provide testimony and evidence with regard to doing a bit of a deep dive on the property in question. But just to put it in context, I've had multiple interactions with my partner, because we've looked into this to try to see if there's something in the records that we could not locate that would somehow evidence a basis for the violation that we believe exists to be permitted. We find no such history of anything. And so that's where we are as of this afternoon. Respondent is here, counsel for respondent is here, and I'm sure they'll make a capable representation to you, but Officer Miller will give you the outline, and as I say, Ms. Manning is here as well for your ratification.
Okay. And since you gave an opening, do you have any objection to
No.
counsel? If you have an opening, since the city took one, I'll give you the same opportunity. No? Okay. Yes, ma'am.
Good afternoon. Alex Miller, Community Compliance Officer for the City of St. Cloud. At this time, I would like to enter into evidence the following items: copy of the notice of violation sent by regular mail, copy of the notices of violation sent by certified mail, copy of the statement of violation and notice of hearing sent by certified mail posted at the property in City Hall, copy of the PowerPoint presentation, affidavits of postings, evidence of mailings, copy of the code sections in violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $337.42. On December
Do you
11,
have a binder?
I'm sorry.
And was counsel for the respondent provided a copy of the binder?
On December 11, 2023, during routine patrol, I observed cattle roaming around this location and a barbed wire fence was installed at this property. I verified that there was no permit on record and this property is zoned for highway business, and having the cattle and the barbed wire is prohibited and the property was in violation of the city codes. Our city records reveal that there is an application for a site development submitted on August 29, 2023 to build apartments at this location. Copy of the application is on file, I believe. On December 14, a notice of violation was sent by regular mail to the owner agent to correct the violation. On December 27, a reinspection was performed and verified that the violations were not corrected. I called the owner and left a voicemail advising him of the violations. On December 28, a notice of violation was sent by certified mail to the owner agent to correct the violations and 2 photos were taken. On January 25, after verifying that the property was not in compliance, an amended notice of violation by certified mail was sent to the owner agent for the violations to be corrected, posted the property in City Hall, and 2 photos were taken. On February 2nd, I verified that the violations were not corrected. I worked together with the Planning and Zoning Department to verify that there was no agreement on record with the city that allowed the barbed wire and the cattle at this location. No agreement was found. Annexation documents can be provided to the defendant. On March 4th, a reinspection was performed and verified that the violation still is not corrected and 2 photos were taken. On March 8th, a statement of violation and notice of hearing was sent by certified mail to the owner agent, posted the property in City Hall, an affidavit of posting was created, and 1 photo of the posting was taken. On March 15, I verified that the violations were not corrected and the property is still in violation, and 2 photos were taken. It is the city's recommendation that the respondent be found in violation of allowing a barbed wire fence to be installed prior to obtaining a permit and having livestock where the use is prohibited with the zoning conformity and not correcting the violations by the time specified. The city will recommend that the respondent be given until April 30th, 2024 to correct the violations, or a fine in the amount of $250 be assessed until compliance is met. The city will also request that the cost incurred in bringing this case before the magistrate in the amount of $337.42 to be paid within 7 days of the in order by the special magistrate. And this concludes my presentation.
Still, don't go far. I might have a couple questions, and I'm going to ask counsel if he has any questions for you. just so I understand the city's position as to what violations you're seeking relief on. As to the fence, there's two. There's that the barbed wire fence is not allowed in the zoning district.
Correct.
And the fence that is there, regardless of barbed wire or not, was not permitted. There was no
Correct.
permit issued for it.
Correct.
And then the other violation is the location of cattle, which I take the case to be that the code does not allow cattle to be kept on highway business zone property.
That's correct, sir.
Something?
No, just if council did not have questions of Ms. Miller, I wanted to prompt for Ms. Manning to give her testimony to you about her research into the
Okay.
property from the planning department.
Okay. And is it Mr. Mondor? Did I say that right? Do you have any questions for the or the community compliance officer?
Just one.
Come up. And if you would just state your name for the record too, for me, even though I
Brian
just said it.
Mondor. In regard to the ordinance that
Just
restricts.
pull that mic up a little bit so they can make sure they get it you on the recording.
In regard to the ordinance that restricts where the cattle can be placed, you stated that it was highway business. Was that city code section 8-5? I just wanted to make sure.
So 8.5 will be the prohibited use, I believe. I have to. Get a copy of all. Okay, so this is a 20 as a general restrictions where it says.
Pull that mic. I can't hear you either.
Sorry, the 3.20.2 Land Development Code, point B states that agricultural districts, if there's agriculture, they can have and maintain barbed wire, but this is not agriculture zoning. Sorry, what was that question?
But I think the question was related to the restriction on livestock, right? Was that the question, council?
Yes.
Which, as I'm looking at 8-5, and I think that is where that provides language related to the keeping of livestock. But I think the question was related to 8-5.
Right here. Yep, 8.5, yeah, 8.5, that's a city code.
And so, as it relates to 8-5, and just to ask a follow-up question to council's question, is this property located within 150 feet of residential building?
Yes, it is.
It is?
Right across, yeah, it's right across the street, there's a apartment complex.
Okay, thank you.
Can I just get clarification from Officer Miller for you, Your Honor?
Yes, sure, go ahead.
The violations are captured within Land Development Code sections 3.20.2B3, 3.3.1F, and 13.3 and 3.4.11A of the Land Development Code, correct?
Correct.
And also section 5 City Code.
Yes, sir.
Okay. Unless council has further questions, or you did, Your Honor, Ms. Manning,
You know, one second, I'm just making sure that I don't. I was looking at 320 to make sure that I didn't have any questions about that. Okay, I have no further questions for this witness. You can introduce your next. Hello, if you would state your name and title for the record first,
Yes,
please.
Tisha Manning, zoning manager for community development. So when this case was brought forward, Alex did come to me, and so I did thorough research on this property to ensure that when it was annexed into the city, it was not annexed with any special conditions of, you know, bringing forth livestock or barbed wire and things like that. So in my research, it was discovered this property
If
was.
I don't want to throw you off, but let me pause. When was it annexed, just so I have the historical background in my head?
Yes,
How
it
long
was
ago
annexed in 1988.
Okay.
And it was 2 parcels that were annexed, and one parcel was annexed and assigned a zoning designation of R3, and that is the one I believe in which they're building the apartments on now. And the second parcel was annexed and assigned a highway business zoning. Neither of those zoning districts support livestock or the use of a barbed wire fence. That is only permitted in agricultural zoning districts.
Anything further from this witness? No, that was it? And counsel, any questions for this witness? Ma'am, you're excused, thank you. Any other witnesses from the city?
No, sir.
Okay. Respondent, your turn. Counsel, you seen it? Oh, just make sure it's made down in that objection.
And let the copy keep for the record.
You can have this one when I'm done with it. You can have it. I don't need to take it back with me. Thank you.
So as has already been discussed, my client Preferred Vista was noticed for violations of the following St. Cloud Development Code sections: 3.20.2B3, 3.31F, 13.3, and 3.411A, in violation of St. Cloud City Code section 8-5. I will go in order. Turning to section 3.202B3. That section does not exist. It ends at 3.20.2B2, but it appears that they're citing to subsection C3, which is under the caption residential dwelling districts. As has also been discussed, this property is zoned for highway business, not residential dwelling or in a residential dwelling district. So this section of the St. Cloud Development Code does not apply to my client's property. However, even if it did, under the Florida Right to Farm Act, which was enacted in June 16th, 2000, cities and counties are prohibited from enacting ordinances or adopting ordinances that would restrict or otherwise prohibit farm activities on property.
Do you have a copy of the legislation?
Yes, I do.
Thank you.
I also have, can I,
Sure, you can approach.
it's the Attorney General opinion.
Thank you.
The number 2 is highlighted.
Okay.
And may I proceed or?
Give me a minute to review and so that I keep up with you.
Okay.
Jack, do you want to look at these just while he continues? If you'll back once he's had a chance to look at them, just so he's seen them too. Now you can go on.
Thank you. So, as I was saying, the Florida Right to Farm Act was enacted on June 16th of 2000, and essentially provides that a county or municipality may not enact ordinances or adopt ordinances that regulate, restrict, or otherwise impede farming activities on property.
Is that every property everywhere, or are there limitations to it?
There are limitations to it. It has to be a bona fide farming operation. A property, in order to be deemed a bona fide farming operation, is one of the requirements to receive an agricultural exemption under Section 193.461 Florida statutes. The property does have an agricultural exemption, and there is case law, livestock and cattle are farming activities. This St. Cloud Development Code, Section 3.20.2C3, which it still applies to residential dwelling districts, but even if it did apply to our client's property, was enacted on December 14, 2000, which is nearly 6 months after the Florida Right to Farm Act was enacted.
Well, C3, if we're talking C3, why would C3 violate the Right to Farm Act? C3 just says you can't have barbed wire.
Yes, well, this is saying, C3 applies to residential dwelling
Sure,
districts.
I understand your argument why it doesn't apply, but I think you just said that if it applied, it would be, but this part wouldn't be, this wouldn't violate Right to Farm Act. C3 wouldn't.
Yes, it would.
It just said you can't have barbed wire. It doesn't say you can't have cows.
Well, in order to have cattle.
I've seen cattle raised without barbed wire.
Okay, that's fair. Well, I guess besides that,
I think there's other codes you might want to make the argument too.
Yes.
That's why I didn't want you to focus too much on C3
Okay.
when there might be others you want to argue.
correct. So turning to the next set of violations, there are 3 related to permitting, Section 3.31F, Section 13.3, and Section 3.411A.
Let me catch up with you.
Okay.
While I'm catching up, explain to me the interpretation of the Right to Farm Act you're presenting to me, basically, if I understand it, and you may still be fleshing it out. So if I'm jumping ahead, that's okay, I can wait. But just while I had this little pause, let me ask the question that's weighing on my mind. So if I accept that Right to Farm Act says that no city anywhere can adopt any zoning regulation that would prevent somebody from a bona fide farm operation, what keeps my neighbor from having a bona fide farm operation and putting a farm next to my house?
That was the intent of the act.
I don't think it was, but I'll let you explain to me why it was.
I believe in subsection 1, the purpose of the act was to protect farming operations from increasing pressure of urbanization.
Existing farming operations, yes?
Yes, bona fide.
When was the farming operation on this property established?
Before it was purchased in October of 2022 and continued all the way through.
When was the ordinance adopted?
The ordinance with
These ordinances.
the one that we had just discussed.
Was it a bona fide farming operation when these ordinances were adopted?
I don't believe that would be an issue at the time, because in order to be a bona fide farming operation, you have to be engaged in those farming activities for more than a period of 1 year.
Right, but if I'm understanding what you're arguing, is that the Right to Farm Act prevents a local government from enacting an ordinance that would take away an existing bona fide farming operation, take away their rights to continue that operation.
Yes, from enacting to take away. I believe so. But, okay, so I'll jump over. Within the Florida Right to Farm Act, under Section 6, it provides that property classified as an agricultural land pursuant to Section 193.461, the city cannot restrict, regulate, or otherwise limit an activity on a bona fide farming operation or farm activity.
Right, but what if the ordinance predated that? Because I think
The
that
Florida Right to Farm Act?
Yes, no, not the act, the establishment of the bona fide farming activity, because I agree with you, the act was enacted, or the legislation was enacted to protect existing farming operations.
Yes.
But if the ordinance was adopted when if the ordinance restricting farming, this is why my neighbor can't tear down their house and build a farm, because there's not a farm there now. the ordinance that says, no, this is a residential district, predated the establishment of the farming operation. Which, as I'm looking at the facts, that's what I'm seeing here too, a similar fact pattern. So that's why I'm engaging in this, to kind of let you know where I'm thinking, so you can address how I'm thinking, so I can understand your arguments in context of what I'm thinking.
So let me know if I'm missing the point here, but as I've said, this property has historically been used for agricultural
That's what I'm looking
purposes.
for. Okay.
Since well before it was purchased in 2022. It had received a 5-year agricultural exemption for citrus trees well before it was purchased.
When was that?
I believe it recently expired. So if they bought it in 2022, it recently expired 2018, 2017.
Okay. Was there an existing agriculture activity at the time these ordinances that we're talking about were adopted?
I'm not aware of no, I do not know.
So this is my hurdle, and I'm telling you so you can try to overcome the hurdle. As I understand the Right to Farm Act, it says that a local government cannot adopt a law that prejudices an existing farming activity. If there was no existing farming activity at the time of adoption of these ordinances, they cannot violate the Right to Farm Act. If you want, you can take a minute and speak with your client if we need to take a break and you want to think about that a little bit.
Of the question of whether there was a farming operation at the time that.
No, I'm telling you the fact issue that I'm struggling with, and that without facts that show there was an existing agricultural activity that was meant to be protected by the Right to Farm Act at the time the city adopted the ordinance, I don't think the city was prohibited from adopting the ordinances that they did. I don't think the Right to Farm Act says cities can't adopt ordinances that say you can't put farms here. What cities can't do is adopt ordinances that say that farm can no longer be here.
Okay, well, I'll move on from that. That isn't really dispositive
Okay.
of the issues. So just recap, section 3.202B3, that does not exist. C3 only applies to residential dwelling districts. Our client's property is zoned commercial business. Turning to the other 3 violations that relate to permitting. Section 3.3.1F, 13.3, 3.411A. Section.
Just take one at a time.
Okay, so I'll start with 3.13, titled Permit and Permit Fee Required. Provides, it shall be unlawful for any person, firm, or corporation to construct, erect, alter, repair, enlarge, move, or demolish any building or structure, or to erect, install, enlarge, alter, repair, remove, correct, or replace any electrical, gas, mechanical, or plumbing system, or cause any such work to be done within the city without first making an application and obtaining a permit. Here, the issue here is a barbed wire fence. We didn't construct any building.
Fences are structures.
That's a structure?
Fences are
Okay.
structures. Under building code, fences are structures.
Okay, well, under section 604.50 Florida statute, any non-residential farm building, farm fence, or farm sign that is located on lands for a bona fide agricultural purpose, which is as defined in section 193.461, is exempt from Florida building code and any county or municipal code or fee. So the fence, the farm fence, would be exempt from the 3 violations issued by the city of St. Cloud that relate to the need to obtain a permit and not paying a permitting fee in advance.
Okay.
Lastly, the remaining violation is section 8.5, livestock enclosures. The city presented evidence that we are precluded from having livestock on the land because we are zoned for highway business. We were issued a violation for having livestock within 150 feet of any residence building. We do not believe that the livestock enclosure, it was within 150 feet of any residence building, but if it is determined to be so, my client has no issue with pushing back the livestock enclosure to comply with section 8-5. In all, for the reasons that were presented, we do not believe that the residential dwelling provision applies to the property. We believe that the property, the farm fence, is exempt from Florida Building Code and county or municipal codes or fees such as the St. Cloud Development Code, and that Section 8.5.
Do you have a copy of that legislation, by the way, the exempting legislation for the fences?
Yes, it included in
Can I-
tab 4.
Oh, you have
Of
it
your
here.
binder.
Never mind, Jack.
604.50 Florida statutes.
What's urban agriculture? Do you happen to know what 60473 defines it as?
604.73 urban agriculture. No, I don't have a copy of that in front of me.
That's right. I can pull one up. That's what I asked about. It's referenced in the same statute. It's the definition of urban agriculture for anybody who's not looking at it. So like I guess another of you, looking down, I didn't see what y'all were doing. Urban agriculture means any new or existing non-commercial agricultural uses on land that is, one, within a dense urban area as described in 380.06513A. I don't know what that says yet, but I'm interested in that too. Not classified as agricultural pursuant to section 193.461. And I think you've stated that this property is zoned agricultural.
Yes.
Or not zoned agriculture, but designated agriculture pursuant to 193.461.
Yes.
3, not zoned as agricultural as its principal use. And 4, designated by a municipality for inclusion in an urban agricultural pilot project, and nobody has specified to me that this is that. I emphasize that "and" because I think another potential hurdle that I may need you to overcome to be convinced is number 3, which was not zoned as agricultural as its principal. No, you've covered that because this isn't zoned agricultural as its principal use, so not a hurdle for you, hurdle for them. All right. Well, I've got everybody waiting for me. I'm going to go ahead and look at 380.0651, which was referenced in there for that dense urban area. I hate it when they have definition sections that aren't in alphabetical order. Here we go. I get it now. All right, so the subsection is entitled Exemptions for Dense Urban Land Areas. And it says the following are exempt from the requirements of 380.06, but now I understand that they're referencing this in the other section that we were looking at as the definition, these next few subparagraphs, as the definition of what a dense urban area is. Dense urban land area would be any proposed development in a municipality having an average of at least 1,000 people per square mile of land area and a minimum total population of at least 5,000. Any proposed development within the county, including the municipalities located therein, having an average of at least 1,000 people per square mile of land area. Again, that 1,000 per square mile seems to be the main thrust of what makes it a dense urban area. So to the extent anybody needs to factor that into an argument. Okay, I've humored myself long enough. Let you get back to your presentation.
Okay. So regarding 604.50, I guess, did you have any questions on that, what you had looked into? Or rather, its applicability?
I don't have any more questions for you. I understand your argument, and I will give the city a chance to respond, but I understand your argument.
Okay.
Yes, sir.
So to be clear, we're not, as it was mentioned earlier, my client obtained a conditional use permit. They're required to obtain a permit within a specified conditional use permit for multifamily apartments.
Okay.
They're required to pull permits within a specified period of time. We're not asking to be allowed to have these cattle and barbed wire on here for forever. We're asking that we're able to keep the cattle and barbed wire on the land. We'll push the fence back to comply with 8.5, just until we anticipate to break ground, which would be the end of December 2025. Or if ground break happens earlier than that, obviously we would be willing to remove the cattle before then. But the agricultural use on this land, which has gone on for a very long time, longer than the cows have been alive.
What was the agricultural use prior to the cattle being on the property?
Cattle and citrus.
Okay.
It has benefited the neighboring properties and the city of St. Cloud. There's been a history prior to my client purchasing the property of a homeless population that was camping out that was subsequently remediated when they cleared the land for the citrus trees. The property was previously cited for overgrown grass. That was also taken care of by the introduction of cattle, which continue to graze and prevent the grass from growing beyond what is permitted under the city code. When we first received notice of the Section 8-5 violation, we had offered to push the fence back. I do not believe we heard back in response to that request, but my client's here to resolve this. So if it is determined that they're in violation, they are more than willing to push the fence back to be in compliance. That is all. Thank you.
Okay. Don't go far. I might have questions for you. Okay, I think you're safe for the minute. I do have some questions for the city. You can I may ask you to come back up, but let me ask them a couple of questions, and probably more for the attorney than the code enforcement officer. So you've heard the arguments, and I hear some merit to some of them. I've said what I believe is right on the Right to Farm Act and the timing of everything, and on that issue, I think the existence of the code prior to at least anybody presenting anything to me today that there was an agricultural use at that time, I think that is fatal to their Right to Farm Act. However, I am leaning in their direction on the zoning issue, because I'm looking at the notice of violation, which cites 320.2 B3. I agree. I think that was meant to be C3. Although that was to that's the barbed wire. That's the existence of the barbed wire on the property. But 320.2C3 is not cited in the notice of violation. However, subsection 4 does give the statement of the violation, which is failure to prohibit, rather allow barbed wire fence to be installed prior to obtaining a permit. So I am struggling a little bit with the B versus C, but more significantly, because I don't think the fence is the major issue in the case, is the location of the cattle and the use of the property as agricultural, because I see where 3.3.1 F was cited, but 3.3.1 F is not the zoning categories. 3.3.1 F again seems to be more towards the fence and the development of property. And so
I think the livestock was focused more on section 8-5,
let me,
which is with the restriction of that operation. And if I could, not to interrupt your thought
no,
flow,
I'm happy for the interruption.
but there's the fence, albeit the barbed wire would not be something permittable. There's no permit. Was technically what the violation was with regard to the fence, but the livestock is what's driving the violation. We do have. I've got a packet of history on the property going back to 1988 when the application was made to change from agricultural to highway business. And contained in those documents, and council has a copy of this packet, is a statement of intended use, which is dated June of 1988, which sets forth.
I'm okay. Nobody has argued to me that there was agricultural existing on there when these ordinances were adopted. So that argument hasn't been made. I'm not going to ask you to rebut it.
I thought I had heard that.
No. I was saying that nobody has made the argument that there was
Yeah.
agricultural at the time of ordinance adoption, which I think is critical to the Right to Farm Act analysis and to the city's benefit on the argument, the way I interpret the
Sure.
application of law to these facts.
Sure.
As to the fence, and I left this out when I was trying to let everybody understand my thought process so far. Respondent's attorney cited 604.50, and I think he gave you a copy of it in the packet, but if not, you
I have
can
it.
borrow this one. Why does that not apply here to exempt the construction of fence from permitting?
Well, for one, it's arguable whether the lands are used for bona fide agricultural purposes. I mean, it's zoned highway business. We don't have anything but council's position that it's a bona fide use for agricultural purposes, and it's been historically, and it goes back to the application in 1988 for the stated intended use to be, as I mentioned and had a moment ago identified, consistent with what their subsequent acts have been for multifamily development, which was mentioned with regard to the conditional use statement by council. Specifically, statement of intended use, type of use, industrial, commercial, professional, single-family residential, multifamily residential, et cetera, commercial and multifamily. That's sub 1, submitted and in the packet dated June 28, 1988, with regard to the property. So that's more consistent with where this is going. The property is not, in our estimation, a bona fide agricultural use. It's a use that's being adhered to at the moment, but they're going to develop the property, number one. We think they've been properly cited with regard to that violation, which is really what's driving it, because the barbed wire fence is obviously tied to the containment of the livestock, which if we're confident if the livestock are resituated, then the fence issue will be readily resolved. And we've tried to readily resolve this with the respondent, certainly in the spirit of amicable resolution. We have a very good relationship with council's office and so forth. I do want to, and I can proffer testimony from Ms. Manning, there is no conditional use permit on this property. There is none.
It's what's happening in the future is outside of the case today. So I don't need any evidence as to the conditional use permit unless it somehow relates to what's going on right now.
Well, only insofar as it was presented as part of the intent by the respondent for the treatment of the property. But I think that belies the position that it's a,
I think they were more. I think they were. That was more of an olive branch, trying to give opportunities for everybody to work together and maybe allow something to stay for a
That-
little while longer.
yeah,
But
well, that-
that's not for me to decide.
right, I'm confident that can be readily achieved after a finding of noncompliance. Certainly, the end of 2025 would be something outside of the city's realm of reasonable, but I think that Section 8.5 is pretty clear that the violation exists, and it has nothing to do with that section with a building or a fence or any structure. It just simply has to do with the livestock itself.
I'm looking for the definition of bona fide agricultural activity. Can either of you point me in the right direction in one of these binders? It's probably going to be in. Is it in your binder? Do you know what tab? All right, that works. Thank you. And what subsection am I looking for that? Do you know off the top of your head, since I took your copy here? Highlighted? Yes. Thank you. Okay. So I'm going to, again, for everybody's benefit, I'll read this out loud. This is 193.461 3B. Subject to the restrictions specified in this section, only lands that are used primarily for bona fide agricultural purposes shall be classified agricultural. The term bona fide agricultural purposes means good faith commercial agricultural use of the land. Then we have sub 1, in determining whether the use of the land for agricultural purposes is bona fide, the following factors may be taken into consideration. A, length of time the land has been so used. B, whether the use has been continuous. C, the purchase price paid. D, the size as it relates to specific agricultural use. Skipping over a little bit there. E, whether an indicated effort has been made to care sufficiently and adequate for the land in accordance with accepted commercial agricultural practices. Leaving off a little bit of that one. And then F, whether the land is under lease, and if so, the effective length. And then G, such other factors as may become applicable. So what is the city's argument that I should not consider this a bona fide agricultural purpose?
I didn't hear anything proffered by council that meets any of those criteria in terms of the amount of time that's any commercial activity, any proof of commercial activity, lease term, et cetera. All I've heard by way of testimony has been the future development of the property and the fact that there's livestock on the property. I haven't heard, other than that, there's a claim that there's been historic use of this property for livestock going back, I don't know how far, he said it went back, but we've got documents showing that they changed that agricultural use to highway business as recently as 1988 and
Okay.
forward.
Now I think I see where that was relevant to your argument. So let me let you get that in now, because now I think I see what argument you were making. As to the 1988, the clarification or the declaration of uses, or what was it that you were
The
wanting to
statement of
proffer?
intended use, what we have here, you have, I believe,
Is it in the binder?
have you not submitted? I can give.
Was it in the binder?
No, this is.
Let council see it
Council
first.
has a copy.
Okay.
Council has a copy. Go give me the entire package.
Thank you.
There's an application in 1988 to change the use from agricultural to highway business. And there's a myriad of documents that go back and forth with representation, council and so forth, meetings with city and so forth. But what I've got, and I've turned to, I don't have a page number, but it's the statement of intended use. It's this document, sir. Your Honor, it's the statement of intended use.
Mm-hmm. Which paragraph? That's what I'm looking at right now.
Well, it's, apologize, excuse me. It flows from the top, but the critical components are contained in the top third of the statement of intended use. Undersigned petitioner's annexation, property, said petition being forth herewith filed, et cetera. Type of use, number 1, industrial, commercial, professional, single-family, residential, multifamily, residential, et cetera. Underneath that, commercial, multifamily. It says it right there. Now, that's a change from the agricultural to the highway business. That would seem to strongly contradict the statements of the historical use of this property as agricultural. They made an overt change back at that time. And there's been nothing, and Ms. Manning is here to fortify my position, there's nothing that's changed that categorization since such time. So that would first and foremost raise a significant red flag as to whether or not there's a bona fide agricultural purpose being used on the property, certainly that's permitted within the zoning, which is really the...
It's meritorious, yes, but I don't think it's a severe red flag. I think the impact, at least as I read it, it's relevant, it's material to me, yes.
Well,
I don't read any, and not that you're alleging bad faith, but
No.
I don't think there's any unfairness in opposing counsel's argument
I
either.
don't mean to suggest such.
Because
Understood.
I, as a developer, and actually, I happen to know the Battaglia family because they're a developer in one of the cities I represent, and I have seen them with intention of eventually building development, some commercial, some residential.
No question.
Even though I know that's their intent 5 years from now, they may continue the agricultural until they break ground on that. So I don't know that just saying in the future I intend to do this is the same thing as saying I'm never going to do this again.
No, I understand, and I'm not suggesting any kind of bad faith or anything of that nature. I'm simply trying to point out some contradictions in the presentation of respondents' position with regard to the use of the property. And again, all the city is seeking is compliance and a reasonable time from which to achieve compliance with regard to the livestock. It's the livestock that's driving this case.
Understood.
And the location of the livestock in a highway business district, which is not...
When was the property rezoned?
That would be for Ms. Manning to, ma'am, can you come and provide that? Ms. Manning will provide you all of that historic information.
The property was rezoned in conjunction with the annexation in 1988.
Was there an
And-
application made for the rezoning?
It is included with this annexation. It states it in the
Is-
documents.
Is that in the packet that I was just handed?
Yes, it is. Let me find the page. If you look on the very first page, it says annexation, and then it talks about the zoning as ag, and it talks about the change.
Hold on, and that's so,
I apologize. All the paperwork mixed up. I can give you the paperwork on the computer.
show counsel what you're going to show me. Show counsel for the respondent what you're going to show me before you show me, please. Print a copy of this and provide it to the clerk, please.
So right up under type of request.
Hold on, let me get there. So I have application, first thing I'm looking at, application, site plan review process. Am I looking at the same thing you are?
Yes, sir. And
Okay.
then you go down to type of request.
Yes, ma'am.
It says annexation, and it talks about the existing county zoning and what they're changing it to when it comes in for annexation, which is highway business and R3.
And who is the applicant on this application?
So it was William Battaglia.
Anything else for your witness?
No, not with regard to the...
Okay. Where did, oh, there you are. Would you mind coming? So, you saw this, but, Alex, if you would, if you want to have that in front of you, but, so, I think that is the most material piece of paper that I've seen. Because that is the owner of the property in 1988, when he's coming into the city. Affirmatively, that, I think, is what the other document did not do, what the statement of intended use did not do. That is an affirmative act to take away agricultural uses and put different uses on. Because the owner of the property at the time that he came into the city petitioned to rezone from agricultural to a use that would not allow agricultural.
I agree with you.
Okay, so I think that's significant to the case you're presenting to me. Would you like to rebut it?
Yes, so I'll start with the bona fide farming operation. Those factors are in there in determining whether or not the property is going to be issued an agricultural exemption. Property has an agricultural exemption, therefore it has already been determined that it is a bona fide farming operation.
Did anybody tell the state that it was zoned for a district that didn't allow for agricultural?
The property is either it's not zoned. the property appraiser.
But it's zoned by the city is what I'm asking. Did anybody tell the state when that was applied for that it was zoned in a district that did not allow agricultural?
I'm not aware of what was included in that application.
Had the state been aware of that, would the state still have issued an agricultural designation?
I would assume that the state would,
They don't always ask.
well, in connection with having to apply for an agricultural exemption, assuming property records need to be submitted, such as land size, sale price, all those factors in determining land use, which shows the zoning that the property.
Clerk's asked me to get you to speak in the mic a little bit. Yeah,
Don't need
no
to
problem. So your argument really boils down to the state has recognized it as agricultural, as bona fide. The state, by giving the agricultural designation, the state has designated it, has recognized it as a bona fide agricultural operation. Otherwise, they wouldn't have given it that designation. That's the argument, right?
Yes, you can't obtain an agricultural exemption without that. And that's 193461.
Yeah, that's the statute. I thought you were asking if he had documentation that it had the exemption.
That's what I'm asking.
So that.
Fair question. I suspect, though, that that's really what the argument over cows is about. It's keeping the tax liability down until they go vertical. I wouldn't ask anybody that question because I wouldn't ask anybody to tell me that, but that's what's going on.
So it says under 193461 subsection 3A.
I think council is asking for documentation
I don't know.
of the designation.
That's exactly right. I just-
The property appraiser website, if you go down to the bottom, it's classified as AC, which is the agricultural exemption notice on the property.
Sure. Clerk's gonna pull that up.
Okay.
I think I object to the relevance of the.
Well, I'll respond to that. Subsection 3A of section 193461. Lands may not be classified as agricultural lands unless a return is filed on or before March 1 of each year. Before classifying such lands as agricultural lands, the property appraiser may require the taxpayer or the taxpayer's representatives to furnish the property appraiser such information as may reasonably be required to establish that such lands were actually used for a bona fide agricultural purpose. Failure to make a timely application constitutes a waiver. So I believe that the property appraiser's website and any classification indicating agricultural would be relevant.
But you agree that there's a financial advantage to submitting such a designation to the property appraiser, whether or not such operation was actually in existence.
That's taken into consideration when they determine whether or not it's a bona fide.
Who determined whether or not it's a bona? Who, as the argument plays out, who is it that you're arguing has made the determination already that this is a bona fide agricultural operation? Is it the state or the property appraiser?
Based off the subsection that I just read, I didn't read the whole thing, but I believe it would be the property appraiser who has to make the determination. Yes, furnish the property appraiser such information as may reasonably be required to establish that such lands are actually used for a bona fide agricultural purpose. And the 604.50 exemption for fence farms from Florida Building Code and municipal ordinances or codes references a bona fide farming operation as defined in 193461.
Okay.
So since it's been determined as a bona fide farming operation pursuant to 193461, section 604.50's exemption applies to this bona fide farming operation.
So I'm looking at the property appraiser's page for the property. Where is it that you were saying that you thought the?
I believe at the very bottom. Can I approach?
Yeah, absolutely. Here, do you mind? I see the commercial AC. The other thing that I see, though, in looking at it, is there's 0 exemptions.
Where is this?
Exemptions, $0.
Would it show on the tax
I don't know,
records?
but the ag exemption is an exemption, right?
Yes.
So I don't know why if we're relying on the property appraiser for the determination, I don't know why it would show $0 worth of exemptions if there was an ag exemption on the property.
I don't know when the,
You need a mic.
oh, sorry. So it says on the statute, the return has to be filed on or before March 1st of each year. It is March 20th. I'm not sure how the time or process it would take for that to be reflected.
So, well then, but if that hasn't been processed yet, I can't rely on the property appraiser's determination that it's a bona fide agricultural activity if the property appraiser hasn't made that determination yet.
Would my client be able to offer
Sure,
testimony?
by all means. Let me swear him in. I know. Let me swear him in first.
Your question is,
First, do you swear from testimony?
Edward J. Spino.
Do you swear from the testimony you give us the truth, the whole truth, and
I
nothing but
do.
the truth? Thank you. My question is to the agricultural exemption and what's going on there, because it's the agricultural exemption that appears to be being relied on in the argument to establish that this is an bona fide agricultural operation. And so I think counsel was telling me, and better coming from you, that there has been a return filed showing that this is an agricultural activity.
Yes, with
Have you
regard,
received notification from the property appraiser that that's been accepted as an agricultural activity?
I've received an email from the gentleman that I met with at the county who, last year in November. And he has acknowledged that, yes, the cattle are there and that we qualify for the Aggie exemption and that we should have a written notice any time, any moment. But we don't have it yet.
Do we have a copy of that email, or can one be provided?
I have it in my phone, but
Would it be possible to forward it to the city clerk?
I could try to do that, yes.
Or send it to your attorney can send it to the city clerk. But one way or another, can we get that into the record? Because I want to weigh as much as I can, and I know this is frustrating for everybody else but me, but please don't think I am less than patient on this, because I enjoy these cases. I enjoy the exercise of it. While you're doing that, I have some questions for myself on the answer. While he's doing that, let me go ahead and move on to another issue that I wanted to address, probably with both attorneys. So, find the right section. 8-5, which I believe is what the city is relying on to establish the prohibition on cattle on the property. Because the zoning code, the zoning table was not included in the notice of violation. I'm not misreading anything. I know that's your argument, and I tend to agree with your argument, but I want to give the city an opportunity to tell me why that's wrong.
The zoning code was not included in your packet?
No, it was not included in the notice of violation. The actual table of uses, there is a reference to 3.3.1, but it's to 3.3.1F, which goes to again, it's back to the barbed wire, but there is no citation of the section that includes the table of uses that gives permitted, prohibited, conditional, etc.
Can I have a moment?
Yeah, absolutely.
confer?
And the reason why which code is which codes am I giving relief under if it's solely as to the cattle, section 8.8-5, excuse me, that's where the 150-foot requirement comes in. And it is not a flat prohibition of you cannot have cattle in the zoning district, it's you can't have cattle within 150 feet of a residence. And so the math changes for me if we're only looking at 8.5 versus if we're looking at the actual table of uses in the zoning code. Because if it's 8-5 and if the cattle either currently are not or can be moved so that they are at least 150 feet away from a residential structure, I don't see where 8-5 prohibits cattle. It is not a blanket ban on cattle, as I read it.
Well, cattle being somewhat transitory, in my limited knowledge of agricultural
Fences,
operation.
but yes, but
But-
that's what fences are for.
Correct, but there would be a need for the written permission of those owners, all owners within that 150-foot location, which we
No,
don't.
what they were saying, what they had presented was that if they are within 150 feet of a residence, they'll move them so that they're not 150 feet from a residential structure.
And that may comply with Section 8-5. There's still the issue of the permitted use issue.
And that's my question about the code.
That's, well,
If that wasn't cited, I can't rely on that here.
we would certainly make an ordinance motion to have the testimony comport to the evidence.
But
I
they have to react to the notice of violation they're given. I can't add violations here if they weren't included in the notice of violation, even if the
You mean
evidence.
it's a different section, you're saying?
Yes. If they were not put on notice of that I think I would be inviting a due process appeal.
Yeah, understood. If that is, aside from the facts, if that is the concern, albeit with the strength of what's been presented from the city, if that's the concern of the magistrate, then certainly the city, to fortify the position, can certainly renotice and bring it back before you in April.
And if that's the way that I
We'll be right
find-
back here. That's why I started out my presentation, which was not an opening statement, but just to say, hey, we're trying to get this worked out. We've had discussions. I've been scratching my head saying, well, I don't
It's
understand where the
definitely
property
an
was coming
interesting
from.
one.
Understood. Now I have a better understanding, not 1,000%, but I have a better understanding of the respondent's position on it. But I still feel the city's position is the accurate one, all respect to counsel and respondent. But if that's the leaning of the magistrate that from a comfort level, that this be heard in April to allow the city to properly include the tables that are giving pause, we certainly can do that.
Let's talk about that. Anything you want to tell him so he can tell me before I go to the next place? Because I'm willing to explore both. I think what you invited. Yes, sir. And it was sent to clerk? If you'll send it to
Claudia.
clerk, she'll pull it up. That way I make sure it makes the record, because I hate looking at something and then somebody forgets to send it and then it doesn't make the record.
Claudia, here's my name. .clockers at stcloudfl.gov. Yes. It's the same email that y'all sent the notice to. Okay.
If I could, Your Honor, just so I understand Your Honor's position on this.
So let me state it before you ask.
Okay.
So when we look at zoning codes, we're used to, in some form or fashion, R1A, this allows, single-family residential, minimum lot size X, R1B, R1C. And so go down the line, commercial, highway business, whatever it is. There's something in the code that says, this is what's permitted in this zoning district, or this is what's prohibited in this zoning district, and/or.
Understand. Oh, I didn't know, to respond? Just in reviewing with Ms. Manning, she can testify, but there is no reference to livestock in the zoning table for this particular.
Right, because it lists, I'm going to guess, it lists permitted uses, it does not list prohibited uses. And you're going to tell me that livestock is not a prohibited use. I understand that. But was that code section that gives that table that shows these are the permitted uses cited as part of the violation? And that's the key point to me, is
Well, we
that was not
certainly-
included in the notice of violation.
Then we certainly would ask for a continuance. We'll simply renotice it. We'll include the
Well, and
appropriate
so
sections. and ask that we be heard in 30 days.
That's a possibility, and maybe that's the way that I'm leaning to.
Which obviously would give us time to potentially reach a middle ground.
Okay, so I'm
with,
gonna read the email for everybody's benefit. Good. I'm sorry.
Sorry, we found ones from 2023 that I'm forwarding as well.
Okay, so this one from 2024. Well, I'm guessing if if this is all the 2024 one says, 2023 one isn't gonna be more determinative. But everything is good with your property. You will receive certified mail in June or July informing you of the decision. Parenthetical, I see no issues. This is not saying it's been approved for the agricultural designation. Does the 2023 email say anything better for you? So I don't think that gets you quite as far as you wanted it to get you. But let's deviate now and let's talk about this, because I think you kind of were of a similar mind to buy some time. I understand you're going to want to buy more time than they're going to give. I will leave it to you guys. I am not going to serve as mediator here. That is not my role. But I am inclined to withhold today. I'm prepared to rule, and I'll warn you both, it would be a split the baby ruling. You would win on a couple, city would win on some. But on the key point, it would remain pending. Based on what I've seen in the arguments I've heard today, and if I'm hearing it again, whether this case or another one, I would rely on what I hear as to this point when everybody's had an opportunity to prepare their arguments on this point, if it were renoticed. From what I've seen, I think their case is better. I could be wrong, and I'm open to changing my mind when I actually hear that part of it. But I'm willing to withhold today or to continue it today. I'm sure they will go and renotice it. It will be properly positioned. Your well-made and I think accurate argument that this was not in the notice of violation, Magistrate, you can't rule on it today, was the right one. But I think if they get it in the right way, I think it could be a bad day for you and your client, or for your client anyway. And bad just meaning that I would rule the other way than you want me to. So does anybody have an objection to continuing this case with a strong urging from me to everybody put their heads together and find a solution that doesn't involve a ruling for me, because I have a feeling both of you might be a little unhappy with that at the end of the day. Respondent? None? Okay, then that is what I'm going to do. I'm going to continue this, again, with a strong encouragement to find a way of resolving the issues, because I think everybody's point here is well made, and everybody's done a great job today. And I know there's a future development coming, and I do know, just because local government is what I do too, and I've happened to be in a city where the Battaglias have developed property, and this was exactly it. They kept an ag exemption right up until it went vertical. And I know a lot of developers do that, but so I will withhold ruling today and wait for additional information, and whether it's next month or the month after. Okay. Yes, sir.
If it is renoticed, which I assume the city, unless some resolution's made, if it's renoticed for April, would we be able to request that it is withheld, it's not renoticed for hearing until after the June or July decision for the Aggie exemption?
That's between city and respondent. I'll stay out of that one. But as far as notice, I do expect all requirements of this of statute to be met in terms of reasonable time for compliance, notice of violation, reasonable time for compliance, and then notice of hearing. I don't want to see notices that were done just to move it along. I want to see all due process observances made.
Understood.
Didn't think you needed to hear it, but just for the record, I'll say it. Thank you both.
You had more documents that Alex presented, additional.
I'm sorry?
Alex had additional information.
Yes. You got both binders?
I did, yes, thank you.
And this.
And this was Alex?
No, that was respondent's attorney.
Thank you. Case number 2024-65, Chad A. Cabot, owner, location of violation 813 Pennsylvania Avenue.
Can we stop? We have one respondent left, and he's been sitting here patiently, and I hate to
That's
keep
him.
him. Okay, this is your case. Okay. Okay.
Good afternoon, Pam Neal, Community Compliance Officer. I am presenting this case for the property located at 813 Pennsylvania Avenue. At this time, I would like to enter into evidence the following items. Copy of the notice violation sent to the owner, copy of the notice violation sent by certified mail to the owner and posted on the property in City Hall, copy of the statement of violation notice of hearing sent by certified mail to the owner and posted on the property in City Hall, copy of the PowerPoint presentation, a copy of the affidavits of postings, evidence of mailings, a copy of the deed to the property, a copy of the code section in violation, copy of the costs incurred if the special magistrate finds the respondent in violation in the amount of $282.96. On January 9th, 2024, while on routine patrol, I noticed a blue Dodge truck parked in the rear yard that is inoperable at this location. I took one photo. On January 10th, a notice of violation was sent to the owner. On January 23rd, a reinspection was performed. The truck was still there. I took another photo.
Just I'm going to assume, so you're not talking about high grass and weeds was cured before the time set in your notice of
Yes,
violation?
sir. On January 24th, a notice of violation was sent by certified mail to the owner. On February 5th, a reinspection was performed, and the truck was still there. I took another photo. On February 6th, the notice violation with the new date was sent to the owner and posted on the property in City Hall. An affidavit of posting was completed. I took one photo of the posting. On February 8th, I went to the property and took photos. Took one photo. On February 21st and 26th, re-inspections were performed and the truck was still there, and I took 3 photos. On February 27th, 2024, a statement of violation notice of hearing was sent by certified mail to the owner and posted on the property in City Hall. An affidavit of posting was completed. On March 1st, the owner called me and stated he removed the truck, so I went to the property and the truck was removed, and the property was now in compliance. It is city's recommendation that the respondent be found in violation of allowing an abandoned vehicle at this location. The city would like to also recover the costs incurred in bringing this case before the special magistrate in the amount of $282.96 to be paid within 7 days of the written order of the magistrate as well. And that concludes my presentation.
Hey, Mr. Cabot? Do you have any questions for the code enforcement officer before I excuse her from the podium? You can come on up.
I'm Chad Cabot, owner of the property, and one of my questions is that I was forthcoming with you.
Yes, you were.
And I also mentioned to you that I was going through a mail forwarding of my address change, and I gave you the new address and stuff. You also stated that you went off just what the county and property address was, correct?
Yes, sir.
Okay. Now, all the notices that were they sent to the new address that I provided to you?
I don't remember you giving me a new address. If you'd have gave me a
It was
new-
the forwarding address.
It was, yeah. I only had the P.O. box.
Correct.
And that was the one
And I
that's
gave
on.
you the new one.
I don't remember you giving me that new one unless you gave it to me after I had sent everything. Because if you'd have gave me the new one, I would have sent you another, I would have noticed you on it. But all I did was send it to the P.O. box and then I posted the property.
Mr. Cabot, do you remember when you spoke to the community compliance officer about the address?
It was way after the first notice and stuff. I was in the process of mail forwarding, had a Kissimmee address.
What prompted you to contact the community compliance officer?
Because finally, after several weeks of the mail forwarding.
You got the notices.
I got the
see.
notice, and I, called her immediately. I took care of one of the violations, which was the high grass, because that was a quick fix. And then it was like the
How much
truck,
time
and
did it take to get the truck off of the property?
I was in compliance within the last violation, the date. That, can I
Okay.
submit what I have?
Yeah, I may already have it. Let me save you the
No.
trouble. Oh, I don't?
No, sir.
Okay, because I have the notice of violation letters, and the last one I have is February 6, 2024.
Yes, but I'd like to point out something on the evidence that I'm providing, which I have right here, is just the envelope to show the mail forwarding address.
I have that too. I have the return I have the forwarded the envelope with the forward sticker on it.
Just, okay.
That's the post date on that is 25 January 2024. Is that the same one you guys are looking
No,
at?
mine's 2/9 of 24 is the forwarding address. And this is in reference to February 6th.
Okay. You said something that I want to circle back on. So the February 6th letter,
Correct.
it gives a sorry, I'm not looking at the February 6th letter. February 6th letter cites the abandoned vehicle and then states violation to be corrected within 10 working days from receipt of the notice. Is it your testimony that that violation was cured by, or within 10 working days of February 6th?
I'd like to point out on that violation, the very last line, almost, where it says, I have 10 days upon receipt of the notice. And she also did highlight the 10 days, which I'm just, when I received it, being that it goes to a P.O. box, there's a couple days probably discrepancy there.
Okay. Did you get the January 24th letter?
No, sir, because it was addressed to my old P.O. box.
But you addressed the high grass and weeds.
That was, yes, when I finally got the first.
So you did eventually get the January 24th letter? Because it's the only one that cites high grass and weeds.
Okay. And when I did get that letter, which I'm not sure of the exact date, I called her and told her, I was like, I took care of it because I was actually going to do it that day.
So it's your argument that you cured the vehicle within 10 days of your receipt of any notice of violation that's cited that?
Of the February 6th, which states that it has to be done, because I had a couple
Did you receive the
questions.
January 24th before, after, or contemporaneously with the February 6th notice?
I don't recall what exact dates when I received that. Because right now, all I have is the,
February 6th.
yeah, I'm not sure the date when I got the one with the lawn and the truck. Because I did have questions with her, that's why I was coming forward with her to find out, because wasn't abandoned, it was operational, I just used a different car.
Well, it wasn't operational.
And
It's
back
not
to-
operational. It had flat tires. It was not an operational vehicle.
They weren't actually flat, they were sunk in a little bit.
They were flat.
I was
You
just
couldn't.
not
You
using
would have been
it.
unsafe on the road.
So,
So I will make the finding that it was an abandoned vehicle, but the timing of everything is important to me.
Yes.
He's making an argument that the notice says he has 10 days from receipt to cure the violation. He is testifying today that he cured it within 10 days of receipt of the violation. Does the city want to make any argument on the definition of receipt?
If I can say something, I did post the property too.
What date did you post it?
I posted it
on the 6th.
on February 27th was my statement of violation notice of hearing.
When was the property? When was your inspection that you saw the property have been brought into compliance?
I posted it on February 6th, the regular notice of violation. So,
Did you see the posting of the notice on the property? Do you reside at the property?
Actually, I'm staying with my mom, she's elderly, and helping her. So, and the photo she's providing of the posting was on February 6th.
Did you see it? That's my question is
No,
to your
sir.
knowledge.
No, sir.
When did you first become aware that there was a notice a code violation on this property?
For the truck?
Either, because if you found out about the grass, you found out about the truck too.
I'm not sure of the exact date. So my arguing is,
When did you remove the truck?
it was, I believe, the 27th. Yeah, 27th of February.
And is it your sworn testimony today that you did not receive any notice about the violation until at least within 10 business days of that date?
Of what?
The date that you fixed it. 'Cause that's the argument that you're making to me, is that you cured it within the time the notice allowed you to, in which to cure it.
Yes, from the February 6th.
I'm asking you, when did you first become aware that there was a violation on the property?
I don't recall the exact date.
Was the date that you became aware of the violation on the property within 10 business days of the date that you removed the vehicle? Because that's the argument that you're making. I'm asking you to testify to it.
I'm not sure on the exact date.
I can't rule in your favor on I'm not sure. I am not asking for an exact date. I'm asking you to testify whether or not you removed that truck within 10 business days of you first becoming aware there was a code violation.
Actually, it was the 20th.
Yeah, the date that he removed it, I'll accept his testimony. I want the key point for me is when he's testifying he received that notice.
Which I don't recall. I don't have an exact date.
But your argument that you made is that it was within 10 days of you removing the vehicle.
Correct, according to the continued violation on this letter.
I know what the letter says. I'm asking you to give me sworn testimony that says yes or no, I did not know about this code violation until no more than 10 business days prior to the date that I fixed it.
I can't do that, sir, because there was questions in regard in which, I was trying to find out exactly what the grounds and stuff were and what I had to do, so.
Okay. I think that one fact seals it for me. That, and so I don't think I need you to say anything else. So, based on the evidence testimony, I will find in favor of the city, find the respondent was in violation, cured the violation within the time allowed. I understand the argument, but without the sworn testimony that says, for a fact, you did what your argument says you did, I can't rule in your favor, so I am going to order you to pay the administrative costs. Those are $282.96. And as you've heard in other cases, I normally say within 7 days of date of my written order, when I have a warm body in front of me, I always ask, is there a hardship there? Would you like more time? I hear you caring for an aging mother. I understand that, and if you need more time to pay that $282, I am certainly willing to give it.
Is that 7 working days?
So, it would be seven calendar days, but if you want more time, I certainly can do that.
10 days?
I would give you 30.
Okay.
Do you want 30?
Nah, good.
Okay, well then I'll say 10.
All right, thank you.
Thank you. Thank you for your patience also. And thank you for your good humor. I appreciate that. There you go.
Case number 2024-131, FD Property Group Corp. Owner, Rose I. Delgado, Registered Agent, location of violation, 1319 Jersey Avenue.
Good afternoon, Pam Neal, Community Compliance Officer. I am presenting this case for the property located at 1319 Jersey Avenue. This time I would like to enter into evidence the following items. Copy of the courtesy notice sent to the owner, copy of the notice of violation sent to the owner and the registered agent, copy of the notice violation sent by certified mail to the owner and the registered agent, copy of the statement of violation notice of hearing sent by certified mail to the owner and the registered agent and posted on the property in City Hall, copy of the PowerPoint presentation, evidence of mailing, a copy of the deed to the property, a copy of the code section in violation, copy of the costs incurred if the special magistrate finds a respondent in violation in the amount of $286.40. And the respondent is not here.
Thank you. I sense that the property is now in compliance.
Yes, sir.
If you would like to, you're welcome to present to me anything you'd like. But if you would like to and you want to skip over some of the earlier notices and just get to the ones closest to it coming into compliance.
Okay, do you want any of the photos, or you don't need?
Enough to make the record.
Okay.
If you want to go through all of it, if that's easiest for you, that is fine too. It's not, I'm trying to be respectful of your time. I don't care about my own.
No, that's fine. I took a few photos. That was my posting.
Sorry, go back to the photo. That's over 8 inches?
Yeah, it's hard to, right there, see how you can tell?
Yes,
It's
I see
hard,
there.
the pictures. The property was in compliance on March 12th when I did a reinspection.
And what was the most recent notice of violation you sent? What date was that?
The statement of violation or just?
Notice of the last in
Last.
time notice of violation.
February 12th.
Give me
I
a
think he
second.
was having a problem finding somebody to mow it is what it was. I talked to him maybe twice.
Just let me look at that notice. Okay. And then you stated you think the compliance date is what?
It is, the compliance date was March 12th.
Okay, so well after the time you allowed in the notice of violation.
Yes, sir.
And then you served statement of violation and notice of hearing on what date?
The 27th of February.
And did you receive proof of delivery?
I know he signed for one of them. I'm not sure if he signed for,
Yeah, it looks like notice of violations were signed for,
yes, he signed,
and I don't see a green card for notice of hearing. Is the notice I'm looking at, the posting on the property, is that the notice of hearing?
yes. And I think he did sign for that. I got it right here.
Okay. What was the date
Yep.
that he signed for?
February 29th. I sent it on the 27th.
Anything else you'd like me to hear?
No, did you want me to, my recommendations? No? Okay.
I have it in front of me. That's how
Okay.
I was psychic and knew that you were going to tell me the property was in compliance. Jack, anything else you want to make the record with, or are you satisfied with the record that we've made? We got the notices in, we got the violation in, we got the dates in.
Jack?
Are you satisfied with the record we've made? We got the notices in, we got the dates in, we got the violation in.
I think we're all good. Violation.
Based on the evidence and testimony provided, I'll find in favor of the city. Find the respondent was in violation for grass and overgrown weeds. Find that the violation was cured, but it was cured after the date set in the last notice of violation for cure. And based on that, we'll order the respondent to pay the city $286.42. That amount will be due within 7 days from the date of my written order.
Thank you.
Case number 2024-403, IH6 Property Florida LP, owner, repeat violation, location of violation, 510 Snail Kite Avenue, St. Cloud, Florida.
So I can't make your life easier on this one. I'm going to need the record, but go ahead.
Alex Miller, Community Compliance Officer for the City of St. Cloud. You just want me to go to the end, or should I go through the whole process? Go through the whole process?
Yeah, that's why I say,
Okay.
yeah, because this one for what it is, that one because it was in compliance, that's why
Okay.
I shortened it up, but this one I can't do
Sure.
the same for you, so I'm going to need to hear all of it.
Okay, at this time, I would like to enter into evidence the following items: a copy of the statement of violation and notice of hearing sent by certified mail, posted at the property in City Hall, copy of the PowerPoint presentation, affidavit of posting, evidence of mailings, copy of the code section in violation, a copy of the deed to the property, and a copy of the costing curve. The magistrate finds the respondent in violation of the amount of $217.96, and the respondent is not here.
Thank you.
On February 20, 2023, during routine patrol, I observed a commercial vehicle parked at this location, and I also verified that there was no business tax receipt for a landlord license on record, and this was a repeat violation for the owner. One photo was taken, and the findings of fact were also attached to the binder. On February 21st, I verified that the commercial vehicle was removed, and a statement of violation and notice of hearings was sent by certified mail to the owner and agent, posted the property in City Hall, an affidavit of posting was created, and one photo of the posting was taken. January 15, and again today, I verified that the violation has not been corrected. It is the city's recommendation that the respondent be found in a repeat violation of allowing a business tax receipt for a landlord license to not be obtained for this property, and pay a fine in the amount of $500 a day commencing from February 20, 2024, the day the violation was found, until compliance is met. The city will also request that the cost incurred bringing this case before the magistrate in the amount of $217.96 to be paid within 7 days of the written order by the special magistrate. This concludes my presentation.
So the commercial vehicle was cured.
Yes, sir.
Is this a business that's been in operation lawfully in the past and just doesn't have a current BTR?
This is one of the borrower properties, IH Property, Florida. The property has been rented since 2022.
Has it had a BTR in the past?
No.
Okay.
Yes, it did. It had from the
So
previous
this is a
owner.
renewal problem?
No.
No.
This is a new owner. They acquired the property, and they never obtained a,
New owner or new tenant? New tenant?
Yeah.
New business in the space, but the owner is the same, right?
no, it's a new owner. I don't know about the tenant, but I know it's a new owner. So the property was purchased on June 2022. The previous owner had a landlord license, and that was made inactive.
Okay, so the repeat nature of the violation is not as to the property, it's as to the respondent that IH6 has been in previous violation of not having a BTR at other addresses within the city.
Yes, sir.
Got it, okay. Is this an office? Is that what it's being used for?
No, it's a home.
Oh, this IH6 owns it. They're renting it. The BTR is in relation to the rental permit.
Yes, sir.
Got it. Sorry, that's where I was. Okay, the reason why I was going down this line is because for what this is, for a BTR violation, even though it's a repeat, I'm struggling with $500 a day for a BTR violation. It's not life and limb. It's not public safety. That's why I was curious as to the nature of the operation. It was if it was noxious or, there was something that elevated it above just, didn't get a BTR. So I am going to find in favor of the city, order the respondent to cure the violation, not give a date because I will date the fines to February 20th, 2024. But I'm going to reduce the requested fine amount to a fine of $100 per day.
Thank you.
And I will also order the respondent to pay the administrative costs incurred by the city of $217.96. That will be due within 7 days of the date of my written order.
Thank you.
Yes, ma'am. Thank you. Yes.
Unfinished business, none. New business, none. Next scheduled meeting, April 17, 2024.
Anything else from the city? No, sir. We're adjourned.